All right, I am Denton Mak. I'm the managing attorney for Sheldon Mak Anderson. Firm has been in Pasadena since 1983. This is actually our 30th anniversary this year. We've grown up with, the firm has grown up with many of our clients. Some of them I see here.
30 years already?
Yeah. 30 years, 28 with you.
Wow.
So we do patents, trademarks, and copyrights. And with the new lawyers coming in, we have at least one sitting here. We always tell them that for businesses in America, trademarks are really their most important intellectual property because designs change over the years, patents expire, but trademarks are what is most long-lasting. As long as you keep using it, they last forever. So, what is a trademark? A trademark serves the purpose of identifying the source of products and services. So, anything that could be used to identify your company's products and services could be a trademark. The main purpose of trademark law, surprisingly, is not a property rights law like patents. It's not a right whereby you could sell it for money or whatever. The main purpose is to protect the consumers in the market from confusion, from looking at multiple products thinking that confused into thinking that they came from the same place when they did not. Why is that important? Trademarks are only useful for businesses that are successful. You take like Campbell soup, that was a good example. The contents in the can probably cost maybe like 5 cents. And then you put a steel can on the outside. If it's a no-name brand, it sells for 76 cents, as Ellen pointed out. You put on a brand name, you put on a famous brand like Campbell's, and suddenly it sells for $2.15. So to get from, typically for Chinese companies, to get from the ex-factory price in China of 10 cents and go to perhaps $5 or $7 retail in the US, there's a lot of value. And as you become successful, how do you keep the remaining effect of the good feeling that the consumer has after using your product and they want to come back and buy some more of it? The trademark serves as a placeholder where you could put all that, store all that business goodwill. And with that business goodwill, the consumer will be able to come back again and again to buy your products, hopefully. And of course, over time, trademarks for most companies develop into very valuable property rights. I believe there was a study in 2011 saying that out of the $65 trillion property rights in the US, approximately 11 trillion of it was intangible rights, including trademarks, patents, copyrights, and such. So I think the last study of the value of the Coca-Cola brand is worth approximately $25 billion. And the rule of thumb is that for most manufacturing businesses in the US, the trademark itself is probably worth a fraction of the sales, anywhere between 15% to 50%, depending on the profit margin. What can be a trademark? A trademark literally can be anything that could be used to identify the source of a product or a service. So naturally, you can have words as trademarks. And the words could be English, words could be Chinese, and in fact, there are perhaps around 100 Klingon trademarks, the Klingon language, and they actually, somebody tried to, actually successfully use made-up languages as trademarks. And of course, there are logos, such as the T design, T logo design, the Allen design. It could be symbols, sounds, colors, scents, colors, for example. There's a Corning has a insulation that is pink color, and the color could be a trademark. It could be a very powerful trademark. And one class of trademarks, as Mr. Sheldon Mak was pointing out, is that, well, what happens if you have a product and yet there are features that are very desirable, the consumers really love it, but it's not somehow protectable by patents. What do you do? Well, you can go with trade dress. What is trade dress? Trade dress is the appearance of products or packaging. They could become protectable as trademarks if they get secondary meaning. Secondary meaning is a concept basically saying that if you have indicators, you have marks that are not initially protectable, and yet through usage, after you use it so much, consumers tend to identify your mark, even though it's initially not protectable. A sound, a trade dress, a packaging. Initially, they're just, well, they look good, but since you have used it so much and promoted it so effectively, consumers now associate the mark with a particular source, namely your company, then it becomes protectable. Some of the more famous trademarks are trade dress, the Coca-Cola bottle. Anybody looking at the shape would be able to tell you, oh, that's Coca-Cola, and you pay more for it than say RC Cola or no brand cola. Other product features, Louboutin has a line of shoes that has a contrasting red sole. The court said that, well, as long as the rest of the shoe is not red in color, if the entire shoe is red in color, there is no trademark. But if it's white, if it's black, as long as it is contrasting, since your brand name, you have sold so many of it, you have secondary meaning in the design that is protectable. And it was in the news actually in the last couple of months, they seized multiple containers of even big competitors' shoes. Some of them designer shoes themselves. And then this is the Bullard hard hat. You would never think, how could that be a trademark? But apparently, if you look at the three ridges on the top of the hat, that is the trademark that is now registered. Annually, they stop over 50 containers coming in. And then the next one, most Chinese would know. It is the green cap on the Hui Fong hot sauce.
The rooster shop?
Yes. Green colored cap.
Wow.
That, because of secondary meaning, because they have sold so much of it, and they were able to convince the trademark office, well, we have secondary meaning, now it's protectable.
How about the shape of the bottle?
The shape of the bottle, Coca-Cola would be a very good example.
No, I mean the Hui Fong bottle. Would that be
Theoretically, it is possible, but I would think that because they're not either not the first one or not the only one using it, they would have problem registering it because the shape appears to be quite commonplace.
So what you're saying is that the green colored cap,
Yes,
that green,
yes, the
the
color.
neon green is
It doesn't have to be neon green. The description on the registration was actually green.
Wow.
Any green color would infringe.
So if somebody wanted to make another famous sauce, which by the way, I think anybody that likes Asian food and would eat an Asian restaurant knows what that is.
Yes.
If they make it exactly
It could
like
be
that in terms of the bottle and make it a blue cap, that's fine.
With trade dress, you will tend to find that the protection is narrower. So I want to introduce the concept of likelihood of confusion. So before I go into how do you pick a trademark, because you really have to look at it from the legal standpoint, what is the legal system, what are the courts looking for, what does the trademark office look for before you decide, well, how can I pick my trademark? Okay. There's only one unified standard on picking trademarks, on deciding whether or not a trademark infringes a prior mark, and for the courts to determine whether or not there is infringement. Basically, it's called likelihood of confusion. From the layman's standpoint, it really is two similar marks placed on two similar products or used for two similar services. Would the consumer public be confused into believing that they came from the same place? Now, that's not really a legal standard. The courts would have to translate that into something that they could determine, make factual determinations on. In most of the courts, it's a 7 to 13 factor balancing test. The main ones are, well, how similar are the marks? In sight, sound, and meaning. Do they look the same? Do they sound the same? Do they mean the same things? And have the same commercial impressions? Are the products overlapping? Do they sell into the same channels? Are the prices different? If one is a $5 product, the other one is a $200 product, maybe there's less of a chance of confusion. Next is the sophistication of whoever is buying this. If it's a can of soup, perhaps they won't spend like half an hour examining whether or not it is a real product, as versus, say, a Rolex watch. They will probably look at it and see, is that real? And the fame and strength of the prior mark. For example, there are certain marks, when we go into the choice of marks, there are certain marks by choice. The company picked them because they want familiar sounding words. Well, those are harder to protect because many companies use similar sounding words for similar products. So the strength of the mark is one of the factors, and then the number and nature of similar marks for similar goods, that again goes into the strength of the mark, and whether or not there is actual confusion, and whether and many of the courts look at whether or not there was intention to copy. So they look at bad faith and good faith of the latecomer. Now, those are the general factors considered. So now we look at, once from that context, well, how should one pick a trademark? Hi, Alan. Well, the first priority clearly is not the legal, viewpoint. It has to be, will this trademark help me sell more products? Because trademarks are only meaningful if you have a successful business and you want it as a place to store your business goodwill. Therefore, you have to pick a mark depending on where your market is. For example, if you're selling to Hispanics market, you probably don't want a mark for like Nova for a car. Nova in Spanish means won't go. So
And GM did make that mistake?
yes, they actually did. So they ran into trouble in South America. Now, from the lawyer's standpoint, we look at, okay, the client picked the names and they hopefully with the lawyer's input early, and then in the realm of legal protection, trademarks, the more distinctive they are, the easier they are to protect. Therefore, purely from the protection standpoint, you want the more distinctive marks. But from selling the product standpoint, you really have to consult the marketing person or the in-house marketing team and decide, is this trademark going to help me sell more products? But purely from a legal analysis standpoint, there are two classes of trademarks: the arbitrary mark, like Google for search engine services, Apple for computers. They have nothing to do with the products. The name has nothing to do with the products that are covered. And the second type of strong marks would be a suggestive mark, like Dove for soap. Dove is I guess, soft and smooth. It really, I mean, it's not really, it does not describe any, a soap cannot have toughness, so it's only suggestive of the desirable features that you want. So those are the easily protectable ones. But our experience, I've done approximately 1,000 trademarks. Over half of the time, the client always wants something that sounds very familiar, very everyday, that describes the product, like speedy, like crisp, super, select, names of that nature. Those are generally determined to be descriptive, and they are not really registrable on the principal register. In the US, there are two types of trademark registration: the principal registration, which gives you all kinds of benefits, and then there's a supplemental second-class registration, where when you have a trademark that is not really protectable to begin with, you could sort of put it on there first to serve notice purposes. And then there is a class of marks and names such as elevators for elevators, escalators, aspirin. Those have become so commonly known as the actual name of the product, they are no longer protectable. You cannot register them anymore. They're not protectable anymore. They are generic. Okay. So how do you pick a trademark? Well, you work with your marketing people, and then after you identify perhaps maybe 5 or 6 or 7 of them, you should do a search. Well, why do you want to do a search? Because if we look back at the likelihood of confusion analysis, it's not as straightforward as looking at whether or not there's the identical mark registered. There's some sort of analysis required, and you probably want to go with somebody who has done quite a few of these, so that they would be able to just tell you and look at the list and very quickly help you prioritize it and say, well, maybe this mark 3 is easier to register and whatnot, and help you do a search to find out whether the marks are available. Surprisingly, after 30 years, we still have clients that use the mark first, and then a year later, well, my mark is very successful, I want to register it. Well, you're supposed to do the search before you adopt the mark, before you have spent a year marketing it. And it's not unusual, because in the US there are now over 4 million trademarks. You open up the dictionary, there's only 120,000 words. Well, if you can pronounce it, it's probably taken. So you certainly want to do the search first before you adopt the mark. Okay, the US trademark system is actually quite a bit different from the rest of the world. The US is one of only 3 systems that I know about that actually require actual use, before they will allow a registration of a mark. The other 2, I believe, the Philippines and Canada. Most of the other nations in the world allow you to register a trademark without actual use. And not only that, it's not just for the registration purposes. The entire US trademark system is built around use, the concept of use. The general rule is, if you don't have a registration, as between competing users in a particular geographic area, the earlier user wins. And the law is that when you have a trademark, you have to use it. If you don't use it, you lose it. The basic rule is that 3 years of non-use is counted as abandonment. And use for registration purposes has to be bona fide use in US commerce. And it's not just advertising or token sales, ship one to your girlfriend, that doesn't count. It has to be real use in commerce that could be regulated by the US Congress. So that would usually be international sales or out-of-state sales. And since the general rule is that it's between competing users, the first user wins. Well, use under the US law could be either actual use in real commerce, or it could be for priority purposes only. It could also be constructive use. Typically, constructive use is when you file your application to register your mark. There are many benefits for federal registration. There are basically two types of registrations, as I described before, the principal and the second-class supplemental registration, and most of the benefits are under the principal registration. First, you have presumed national priority, depending on the type of trademarks you file. Under the registration based on use, under the foreign trademark basis, or under the international trademark registration, on all of them, you can have an earlier priority date than your actual use. Therefore, the registration gives you that important benefit to be earlier than your competitor. And with a principal registration, you could record your mark with customs, which is probably nowadays the cheapest, most cost-effective way of enforcing your trademark rights, because you have the entire ICE watching over the ports for you. And there are litigation advantages because there are presumptions of validity. You don't have to go in and prove that you actually started using the mark 45 years ago. Well, that's not a small matter if you actually have to prove it. Most people do not keep the documents for 45 years. Therefore, if there's a presumption, it makes your life much easier. There are 4 ways to register a U.S. trademark based on actual use, based on an intent to use. I think I'm going to be using this mark, or based on the last 2 are only for foreigners. They actually give some advantage to the foreigner, as described later. Section 44D is that if you have a trademark in a country that has a treaty with the U.S., such as China, such as actually Taiwan has an agreement with the U.S., and most of the industrial nations in the world belong to the Paris Convention. Therefore, by convention, they could use their foreign application and registrations to register in the U.S. And the newer thing is the Madrid Protocol, for which about half of the industrial nations in the world belong, and you could base on that and come into the U.S. The benefit, the advantage that the foreign applicants enjoy over U.S. company is that, remember I said, you have to use your mark, because basically in the U.S., under actual use and ITU, you have to use your mark before you can register the mark. For foreigners, they don't have to. Based on 44E and Section 66A, they could come in and register the mark. At least for the first 6 years, they don't have to use the mark. However, that's only a partial advantage for them. I'll explain further. Because the use is actually the most important key feature for U.S. trademarks. You need it to maintain the registration and also for enforcement. If you don't use it for 3 years, and if your competitors find out, they could cancel your mark. In U.S. registrations, between the 5th and the 6th year, and every 10 years, at 10th year anniversary, you're supposed to file a sworn statement saying that I am still using the mark. It is under oath, and you cannot lie. If you lie, your registration can be canceled. So at that point, doesn't matter how you came into the registration, whether you came in from overseas or based on U.S. use, you must have used the mark. The expectation is that even if I give you a registration based on your foreign registration, you're supposed to start using it. If you don't, the mark could be canceled. The trademark office used to have a rule that was really, really stringent. There are many foreign applications coming in that in foreign practice, especially Australia, China, and whatnot, they love to list a gigantic list of products. I've seen registrations that cover like over 200 products. And you look at it and you say that there's no way that they are actually using the mark for all of those products. Trademark Office in the US used to have a very, very strict rule that says that if indeed you have this registration and yet you overclaim, for example, you sold only 25 products but you listed 100, your entire application would be canceled. And the rule was so strict that it was strict liability. If you only missed 1 or 2, they could still cancel your mark. But the rule is getting loosened more and more. One of the cases, G&W said that if you overstated in a multiple class application registration, 6 classes, and you overstated in 2, they will only cancel the 2 and leave the other 4. So the law is still changing a little bit, but the takeaway is that you cannot lie to the Trademark Office. Now, again, in the US, registration gives you certain benefits, but the key feature is that registration cannot support an infringement suit. There's a very old case called Dawn Donut that basically said that until the trademark owner moves into the trade area of the latecomer, he cannot get an injunction, and he cannot get a finding of likelihood of confusion, without which you don't get damages. So until you move into the latecomer's area, even though you have a registration, you cannot sue them. So foreigners could come in and have registrations, but they cannot sue people on infringement. Well, that's like having a right that you cannot enforce. So, but still, it is beneficial in that you have the mark, and once you have the registrations, others cannot register over your mark. Therefore, it's a placeholder. Once you start in the US market, it could be very valuable. Actually, in this internet age, Dawn Donut may no longer, be very vital. There are some recent cases that either set that aside or say that the rule is no longer a bright line rule. It's not just that, it's not whether or not you're moving into the area, it's whether or not there is likelihood of confusion, because nowadays with the reach of the internet, you really could be in Los Angeles but doing business in New York or Alaska. Therefore, the courts will now look at all these factors to determine whether or not you are actually, there could really be confusion. Now, so you have now spent the time to pick the mark and spend money to register it. How do you use and protect your trademark after the registration? A trademark, when you use it on your literature, on the description, on the packaging, it is always used as an adjective. It should not be used as a noun. If you use it as a noun, if your customers start to do that, you risk losing your entire trademark as being generic. Escalator. Give me a couple of aspirins. Those are nouns. You could lose your trademarks that way. And when you use a registered trademark, you're supposed to put the R in a circle symbol next to it. If you don't get damages when you sue an infringer. But on the other hand, if you use the R registration symbol, you can only use it for goods and services that are covered in the registration. So you cannot overclaim, but you have to put the registration symbol there to get the full value. And then, of course, you will keep the registrations alive. And between the 5th and the 6th year, if you have a registration, you could turn the mark into an incontestable registration by filing the necessary Section 15 affidavit. And another key point is that if your mark becomes so famous, and now you're in the habit, in the business of licensing others to use your mark, for merchandising deals and whatnot, key point to remember is that all licenses must have quality control requirements. You cannot just take people's money, allow them to run amok with your mark and have no quality control. Otherwise, that's treated as abandonment under the trademark laws. And then most of our clients use monitoring services to pick up conflicting trademarks very early on. The theory is that if you go in and challenge the infringer before they have spent a lot of money establishing the market, establishing their brand, they will probably back off, whereas the brand is worth a lot more to you. And if you know of infringers, you have to take action. If you don't, you could lose your rights, either as part of acquiescence or lectures. International registration. Most of the time, clients after a few years expand into the international market. Regrettably, trademarks are only national in nature. Trademark rights do not extend beyond national borders, so you have to do it one country at a time. And luckily, with the Madrid Protocol nowadays, you could do it a lot cheaper because you're basically only doing the registration from the US and you only do one and cover many countries. Trademark as part of the legal system. I try to tell my clients that, look, I mean, nobody wants litigation, but you have to think always, whenever I look at a piece of doc paper, well, is it going to be useful if I have to sue people on it, or as a defense that if somebody sues me on the trademark? What are the important key sets of papers? Well, how you adopted the mark is important. Like if you hire Alan, save the invoices. And if he developed a portfolio of marks and whatnot, it would be very powerful at the time of litigation. If somebody else comes in and tells you that you've been copying my mark, and you could show them a portfolio, no, our designer came up with this, and you could look at the evolution of it over a period of time, you definitely did not copy your mark. Those are very important papers that should never be discarded. I mean, most companies save their invoices and whatnot for only 5 to 7 years. But these are the documents that you really have to keep forever. First shipment invoices. Like, one typical way of invalidating a trademark is to say that you lied to the trademark office. You really did not sell on such and such a date when you said you did. Well, you kept your original paperwork. You don't have to keep all of them, you keep 2 or 3 of them. Then it would be very convincing, because in the US litigation system, verbal testimony is given a lot less weight compared to documentary proof. For example, we had a litigation case years ago. Thinking back, it literally turned on the fact that the judge looked at a document and we translated the term 水货, water goods, as counterfeit merchandise, and just said, yeah, counterfeit merchandise. And we won the case. So documents speak a lot louder than just testimony. So there are certain documents that run across your desk, you always should be thinking about, should I keep this? Nowadays, with scanners being so cheap, just scan them into your hard drive and forget about it. And other area of planning when you're planning trademarks is make sure that your insurance covers litigation. Nowadays, I think the average is 6 to 7 years between litigation. So if you're doing business in the US, you have to expect that you will be involved in litigation, and it would certainly be nice if there's an insurance carrier picking up the tab, or at least part of it. Advertising injury and the CGL policy is typically where you find the coverage. And other area that we have recently looked at is the newer cyber liability policy that for some reason have much broader language, even though they are arguably intended for only people who have a web presence. If you have a social site and whatnot, and you have brand names on there and you have copyrights on there, definitely get cyber liability coverage. But looking at the definitions, looking at the actual language, we found that there's a good possibility that even in a regular trademark or copyright lawsuit, there may be coverage. So it behooves you to look at least some of the policies to figure out whether it's worth buying it. And other area is that this, especially for smaller businesses. And over the years, I mean, I get asked this question more than once, and we tell them that, look, I mean, the American system really is different in terms of litigation. You are expected to tell the truth. You are expected to produce all of the available documents when you're asked for them. And if you don't, the judge could do a lot of bad things to you. If you destroy documents, if you throw away evidence, the judge could rule that you lose the particular motion, or even that you lose the entire case and could no longer have the right to defend. Even big companies run into that problem. It's only a week or two, every week or two you read about Apple and Samsung in the litigation against each other, running afoul of the court's order for not doing the proper litigation hold. Litigation hold is a new concept in the last 20, 25 years, basically with the advent of electronics and computers. The courts really now expect that once you know that litigation is possible, you as a party and the lawyers have the positive obligation not to destroy any evidence that is relevant, and that includes emails and all the hard files, the faxes and whatnot. And if you do, again, the consequences could be very, I mean, there could be an adverse implication in the case. In conclusion, trademarks as a property right can increase value over time. So I remember a recent case 2 years ago. A small clothing manufacturing client. They've had the mark for probably a registration I obtained for them probably 15 years. But the mark, I mean, they're just using, they're selling perhaps like less than $100,000 in products each year. So the mark, I mean, in itself is not worth much. However, there was a European company that wants to move into the US space, and they happen to like the mark. So with the proper blocking, we register the mark with customs, of course, and we opposed to their attempt to register similar marks. And finally, after a couple of years, they basically gave up and paid my client $1.6 million for a mark that, I mean, they're doing very little with. And trademarks could be worth a lot even after a business goes away. I mean, we have a client who bought the Cooler Cool mark, which came back as the ice cream sandwich in the Dodger Stadium. And we have a client from Hong Kong who last year, with our help, bought a line of toy cars line. And you can no longer buy the cars in the stores, but if you go online and you type in the trademark, you get 10 million entries. So there certainly is still a lot of business goodwill in that. And if you buy that, you could get back into the American market very quickly and still use that residual goodwill. And the good thing is that trademarks, if you properly care for them, they can last forever. Like, I don't know how old the oldest trademark is, and it must be over 100 years. But theoretically, trademarks can last forever. Now with that concludes my presentation, but I do want to remind you that in the green bag, there's a book written by a senior partner called The Manager's Guide to Intellectual Property. It was billed as the easiest to read IP book on the market. Most of the IP books written by lawyers go to 500-600 pages. Nobody reads them. You buy them, put them on the shelf, and forget about them. This book is designed to be written in everyday English and designed to be read in 1 hour. If you're just sitting in the airport or whatever, you could finish reading the book. And it's designed to have a lot of checklists so that you could go back and refer to them. And of course, we hope that you would have many questions and you would come ask us the questions. And to conclude, I want to introduce you to a free online service that we have created called ipscreen.com. Basically, it is the fastest meta search engine that you could use to pick up the IP owned by companies, by the names. For example, what name should we go with? What's a good one?
Strategic like that.
Walong?
Okay.
Huh?
Sure.
Walong. Walong is a famous, well, not famous, but it's sizable Chinese supermarket chain. So, within less than half a minute, it came back with, they have 49 trademarks, 4 copyrights, and two things recorded with U.S. Customs. So we look at what they have recorded with U.S. Customs. What have they recorded? Tiger with design and the best use of it really is if an American company comes to you and says, oh, we've been around for 25 years. That's the best way to check out whether or not they're for real. Any sizable or any company that have been operating for 25 years in the U.S. probably have some intellectual property. If you do a quick search and they have none, you have a lot more questions to ask. At a trade show, a lawyer comes up to your booth and said that this is my design, take it down or whatever. You could very quickly keep them honest, punch in the name of his supposed client and very quickly find out what trademarks, patents they have. So this is a service that we provide for free. And that concludes my presentation. I'd be happy to answer any questions if you have.
I have a question. When you protect a brand, can you do it by state or does it has to be national for the whole United States?
Right. In the U.S., there are actually 51 trademark systems. Most of the states, the 50 states, have their own registration system. However, the federal one is the most advantageous one because of all the benefits that you have, reputation with customs, presumed validity and all that. Most of the state registrations do not give you any of the presumptions. It only puts the latecomers on notice. So, and the price difference really is not that much different. I mean, if you go to a state registration, it'll probably cost you $500, $600, $700. Federal, $1,200, and it covers all 50 states.
In terms of registering in the United States, as well as internationally, you mentioned there's a place you could do it to cover many countries through a Madrid Convention.
Madrid Protocol is actually a office branch inside the U.S. trademark office.
Okay.
So what you do is you file what is called the international registration application, and you designate the number of countries that you want to cover. It's a lot cheaper because of the main reason that in a regular national application, say I have a client who wants to file in Japan, we're not Japanese lawyers. We cannot file in Japan. We would go through a Japanese lawyer to do the work. Of course, we do have arrangements with foreign associates. Since we do the volume we do get better prices and better service. However, the client is paying for 2 lawyers if you file national. Whereas in the Madrid Protocol, you're only hiring me, the U.S. lawyer, to file 1 application. And the foreign lawyer only comes in if there are rejections from the foreign trademark office.
And the cost depends on how many countries you
Yes.
pick, or it's
Because you still have to pay for
paid
the,
for different countries.
for the country application fees.
So typically, let's say we want to register in China, what would be the approximate cost to do that? Let's say
China filing is probably running about $1,500 to $1,700. China, the main problem is that they do not allow multiple class applications. So if you have products that run across multiple classes, you have to do it one class at a time. And the Chinese examination process is quite long. Unlike the US, nowadays they're running 3.5 to 4 months before a first office action, which is unheard of. It used to be like 18 months. China is still about 12 to 14 months, so it takes a lot longer.
You'd mentioned something about after you've been using a trademark for 5 to 10 years, or about approximately 5 years, but within a 10-year period, that you must file some kind of oath with the trademark office. And I've been getting, I've had a trademark for just probably about 6 years.
Okay?
And I've been getting letters from firms that aren't really law firms that are saying, you're going to lose your trademark if you don't act immediately. Please send us $1,000.
Well, it's like the immigration, like notarios in Monterey Park or whatever. I mean, there are a lot of legal services that try to get that business. But basically, for a U.S. trademark registration, between the 5th and the 6th year, you must file a Section 8 affidavit. If you don't file it, they cancel your mark because of the theory.
What is the price for your firm to do something like that?
Section 8 probably. We typically recommend that you do both the Section 8 and 15 at the same time. The Section 8 is the continued use declaration, and Section 15 is the incontestability declaration. What it is that if you file that, then the reasons for which people could cancel your mark really becomes minimal. So the two combined runs about $1,000. Government fees is like $300.
Is that included in that?
Included.
Okay.
Any other questions? Thank you all for coming.